All right, so it's been a hot little minute since we talked about YNW Melly, and there has been an update in this case recently. So, U.S. District Judge Melissa Damian just ordered the Broward Sheriff's Office to release a detailed report explaining why Melly shouldn't be released from custody. Now, this all comes after YNW Melly's team filed a lawsuit a few weeks ago due to the conditions that he has been kept in while he's been waiting on his trial. Now, according to Melly and Melly's team, he hasn't been able to talk to a single family member in over 3 years. He hasn't been able to have any private conversations with his attorneys. And this led to a 12-page lawsuit that they filed against Broward County for apparently violating his rights. All right, so they filed this lawsuit, and it says the petitioner, Jamel Demons, by and through his undersigned counsel, so his attorneys, petitioned this court for a writ of habeas corpus pursuant to Title 28 U.S.C. 2241, asking the respondents to appear and show cause why Jamel Demons should not immediately be released from custody for egregious violations of the United States Constitution. The petitioner, Jamel Demons, seeks his immediate release because he is being illegally detained under conditions that violate the 1st, 5th, 6th, 8th, and 14th Amendments to the United States Constitution. Demons is a black male whose current detention conditions shock the conscious and could not even be imagined in this day and age, even in a third world country that has no guardrails protecting human decency and dignity. For over 3 years, petitioner Jamel Demons has not been permitted to make a single phone call or have a single visit with his family or any other member of the outside world, including not seeing or speaking to his own mother in over 3 years with 3 exclamation points in a court document is crazy. Demons has and continues to be subjected to the type of debilitating isolation that renders his conditions of incarceration cruel, unusual, and beyond belief in a civilized society governed by constitutional safeguards. And I don't care what nobody says, bro. That's fucked up. Again, this man is in jail. He has not been convicted. To not be able to speak to a single person in over 3 years is baffling for a person who hasn't been convicted. I mean, there's people in prison right now that have been convicted of the R word and messing with children, and even they get to make phone calls. So why doesn't Melly? Anyways, it goes on to say he has also had restrictions placed by detention officials designed to impede his interactions with his attorneys and his ability to prepare for trial on his capital murder charges. And again, this is one of them things where if he had got a bond because he's not been convicted, he would be able to visit his attorneys whenever he wants. To have him sitting in there and be impeding his ability to speak with his attorneys is wild, bro. You got the right to a fair trial and to have good representation. Like, he should be allowed to talk to his attorneys pretty much whenever his attorneys want to. His cruel treatment by the Broward detention authorities warrants his immediate release from pretrial detention, since the detaining authorities have shown such callous disregard for his human dignity, right to counsel. Now, a few other things that were listed in this lawsuit was right here when they named Sheriff Gregory Tony and said that he is the one that is responsible for the humane treatment and overall conditions of inmates in Broward County detention facilities. So they name dropped the sheriff. They remind the court that Melly has been detained since February 13, 2019. It took until 2023 for them to get that last trial that he was in concluded, and it ended in a mistrial. So Melly went right back to jail. They talk about how in October of 2023, a circuit court judge, John Murphy, granted a motion to disqualify the state prosecutor in a motion that basically said the state attorney was withholding evidence. Right, so the prosecutor that was on it the first time I covered this trial has since been disqualified, and there's been 2 new prosecutors that's been put on this case, but it seems that they've been doing everything that they can to delay the trial even further. In fact, the very next thing in this lawsuit says a new set of prosecutors have come on to the case and have done everything in their power to delay the trial from commencing. The case is currently stayed pending a ruling on an appeal taken by the state attorney. Meanwhile, the plaintiff, who remains in custody since February 2019, is continuously abused and denied bond. It restates that he hasn't been able to see his mom or talk to his mom in over 3 years. It talks about the unreasonable restrictions and interference with his ability to interact with his attorney. It says that this has included forcing his attorneys to wait for hours to see him, not letting him see them at all, and forcing them to meet with him in conditions that interfere with and impede the privacy and privileged nature of his conversations with his lawyers. All right, so when you hire an attorney, you have a right to tell the attorney certain things, and that attorney can keep that in confidence, in secret. But I'm assuming that they're making them meet in rooms with speakers, cameras, recording devices of some type, right, which effectively impedes his ability ability to have privacy with his attorney. And then this next part is interesting. It says, on or around late April 11, 2022, inmate Jamal Myers filed a grievance report in retaliation of Melly's refusal to purchase him food from the commissary. Inmate Myers filed a grievance report not only against Melly, but another inmate. Inmate Myers alleged in part that Melly was planning an escape by having his attorney bring in 2 handcuff keys to aid in the escape, which is just absolutely ridiculous, bro. Like, dude watched one too many episodes of Prison Break or something. Ain't nobody's attorney bringing them no handcuff key to try to help them escape jail. Like, come on, bro. Anyways, it says, in response, correction personnel conducted a shakedown of Melly's cell and the other inmate's cell in accordance with certain supplemental investigation. Report the shakedown of Melly's cell unearthed commissary and excessive jail issued clothes, which were confiscated and disposed of as per operational orders of the jail. So they basically found nothing when they shook his cell down. But at the same time, I mean, he's in jail, so it's not like you have an expectation of privacy. Like, they can shake your cell down whenever they want. So I'm not gonna act like they did something wrong by shaking his cell down. But what they did next was definitely wrong, because apparently this dude who filed the complaint was Melly's cellmate. And it says right here, however, the other inmate on the dorm was found in possession of the shanks, prescriptions, and other contraband. The inmate was subsequently charged for his possession, and Melly was found to have committed no wrongdoing, and that investigation closed on April 11, 2022. But even though they didn't find anything that was Melly's, Melly was still punished for this. Number 14 says, despite doing no wrong, Melly was moved from his current dorm into solitary confinement, and all phone communication with the outside world was ceased. Shortly thereafter, 2 of Melly's defense counsels attempted to visit him and were not allowed entry into the jail. The facility refused to provide any reason as to the denial. And if you ask me, that's probably a blatant violation of his right to communicate with his attorneys during pretrial. If there's anything in this lawsuit that does lead to Melly being released before he goes to trial again, it would probably be this, because you don't really have a right to communicate with your mom or with your friends, but you definitely have a right to communicate with your attorney. This all led to Stuart Alderstein, one of Melly's attorneys, making a oratinus, which is a motion regarding the jail's interference with the plaintiff's right to counsel, and Judge Andrew Siegel summoned Broward Sheriff's Office Attorney Christian Sobus to court to figure out why this happened. Sobus defended the actions of the facility, stating there was an open investigation against Melly, and further that he was a threat to the security of the jail because he was alleged by Attorney Sobus to have been found with the shank in his dorm. Melly's attorney inquired if any of Melly's defense team were at that time or ever under investigation, and the attorney for the jail said no. The judge instructed this attorney Sobus that the jail could not restrict the plaintiff's contact with his attorneys, and Attorney Sobus would have to come up with a way for Melly to have these visits. As a result of that, Melly's visitation took place in a visitation booth located downstairs in the bond room. The visitation booth did not accommodate Mr. Damons and his defense team in one sitting. Moreover, it was impossible to review any documentation with Melly due to the plexiglass divider. So what they're saying is they didn't give us a private room. They put us in the room where everybody goes to do visits, you know, where they got the divider between you and the person that you're talking to and the little phone that you talk on. Not only was the visitation room not large enough to accommodate defendant's attorneys, but anyone also standing outside of the room could hear everything that is said in the room, violating the defendant's right to a private and privileged communication. On September the 7th, 2022, Attorney Raven Liberty filed a motion to remove visitation, communication, or interaction restrictions. Prior to the hearing on the motion, Attorney Raven Liberty contacted Christian Sobus in an effort to reach a resolution without going to the hearing. Instead, Raven Liberty was met with unhinged screaming from BSO attorney questioning, "What do you talk about? Why do you spend so much time with him?" Christian Sobus ended the conversation in telling Attorney Raven Liberty that if she went forward with the hearing, he would embarrass her. Yo, this attorney for the sheriff's office is a little bit out of pocket, bruh. He's really questioning why a defense attorney would be spending time with a defendant, a client who's facing capital murder charges. Like, dog, that's how this works. It is important to note that plaintiff's defense team was not in possession of the incident report, so the defense team and the court all relied on Mr. Sobus's proffers to the court that have now been determined to be untruthful. Despite the believable threat of character assassination, Raven Liberty proceeded to the hearing on the motion. Christian Sobus ranted and raved about unverified allegations and the behavior of Melly. Despite Christian Sobus's attempts to not only embarrass Attorney Raven Liberty, Liberty, which he failed at, Sobus was instructed to accommodate visitation between Melly and his attorneys that was free of third parties being able to listen. So this would be the second time that the jail had been ordered to allow Melly to have private visitations with his lawyers. The second time that they've been ordered to accommodate this. I feel like maybe the court should have the same rules as the criminals. Like, don't they say 3 strikes and you're out with criminals? Like, how many times did the jail got to be told to allow this to happen before it's a certified problem? On September 29, 2022, Raven Liberty was contacted by a reporter for an online media outlet and informed that an unknown member of BSO contacted them and led them to believe that she, as in Raven Liberty, was the attorney that inmate Myers was speaking about in his unfounded grievance when he said that Melly was plotting with his attorney to get handcuff keys. That's wild. Somebody from the sheriff's office reaching out to the media to try to give information and implicate an attorney is wild stuff. As a result of the accusations of BSO, stories ran for weeks about the alleged nefarious escape plan between Raven Liberty and Melly. The escape plan created by BSO was not the worst of it. December 1st, 2022, under the charge of Captain Hubert, Melly, without cause, was moved to a unit inside the jail that is meant to accommodate 24 inmates. Plaintiff was the only one housed on the vacant unit, with no privileges, no television, and no access to a newspaper. When Melly was allowed his hour out of the cell, all the other inmates had to go back inside their cells. In December of 2022, Lieutenant John Baptiste, along with Sergeant Anthony Kidd, threatened Melly if he told his attorneys about his treatment by telling him they would hide him away from the world. Melly has not had phone privileges since May 8, 2022, and he also has not been allowed to have private visitations with his defense team since March of 2022. That's crazy. As recently, without reason, Melly was moved to the Paul Rain Detention Center and housed on the floor with no one else. His door had been removed from the cell, preventing any privacy, and he had a member of the emergency response team shadowing him 24 hours a day. They were instructed not to speak to him. Melly went without any human contact for several months until again BSO moved him. Florida Statute 901.24 states that a person arrested shall be allowed to consult with any attorney entitled to practice in the state alone and in private at the place of custody as often and for such period of time as is reasonable. The ongoing denial of Melly's access to his attorneys is not only preventing Melly's attorneys from properly preparing for a defense, but is in violation of not only his 6th Amendment rights, but Florida law as well. In order to punish and isolate Melly, BSO have isolated him and not permitted a single phone call or visit from family in over 3 years. This isolation has inflicted enormous emotional impact on him and is designed to deteriorate his mental health and his ability to prepare for trial, a trial that is now scheduled in September of 2025. These restrictions are not for security reasons and bear no rational relationship to any legitimate security interest. BSO monitor the custody of thousands of inmates and have never imposed such restrictions. No non-black inmates currently have any such punitive restrictions. So then it just lays out kind of like a recap of this entire thing. The grounds for petitioning, it says ground 1 is that they violated his right to counsel. Ground 2, he's being illegally detained in conditions that are cruel. And then there's this part that I find interesting. It says prison walls do not form a barrier separating prison inmates from the protections of the Constitution. When a prison regulation or practice offends a fundamental constitutional guarantee, federal courts will discourage their duty to protect constitutional rights. And then they cite some case law there where I'm sure that's exactly what happened in that case. And then they requested that the court make BSO provide a show cause as to why Melly shouldn't be released. And that brings us into the court document that was just released, which is where this judge just ordered that exact thing, a show cause order. Now, BSO has 30 days to respond to this. If they don't respond, Melly will be released. If they do respond, then we'll get to see what they say. And then that judge will make a decision on if she feels like BSO is violating Melly's constitutional rights. So let's take a look at this one, the order to show cause. It says this cause is before the court upon petitioner Jamel Demon's petition for a writ of habeas corpus pursuant to USC 2241 filed on November 2nd, 2024, and motion for order to show cause why petitioner should not be released filed November 15th, 2024. The court has reviewed the petition and motion and the pertinent portions of the record and is otherwise fully advised. It is hereby ordered as follows. The motion is granted within 1 week of receipt of this order. Counsel for the respondents or BSO shall enter a notice of appearance in this case on or before December 6, 6, 2024, BSO shall file a memorandum of fact and law to show cause why this petition should not be granted, and shall file therewith all documents and transcripts necessary for the resolution of this petition. So what that means is she's telling them to give her any of the documents regarding Melly's incarceration, including any transcripts, any schedules. Pretty much, if he's really been in solitary confinement for years on end with no phone calls, no visitation record, then she'll be able to see that based off of all of the logs and everything that she's going to get, especially if the logs don't show that he had any visits from his attorney. Because again, if you ask me, that's probably the strongest point that they made inside of the lawsuit. I'm sure the BSO will probably say something like, oh, we can't let him out because he might tamper with witnesses and things like that, you know. But if they've been holding him in isolation and violating his right to see his attorneys, then it's going to show in the records. Counsel for BSO, so the attorney for them, is requested not to caption the response as a motion to dismiss. Ooh, so she's saying you have to respond. You can't file a motion for me to stop looking into this. Petitioner may, but is not required to, file a reply within 14 days of the date on which the court dockets the respondent's answer, which date is shown by the answer's certification of service. The reply must be filed within 14 days of the date on which the court dockets the respondent's answer. So basically, after BSO responds with the show cause, then Melly's attorney will then have 14 days to respond to that. The reply, if any, shall not exceed 10 pages. So she's basically saying, you know, BSO's attorney can't ask for her to dismiss this. She wants all of the records of everything that's happened and the reason why Melly shouldn't be released. Now, I'm going to keep it real. There's a small chance that this is going to happen, right? It's just the way that the court system works. Melly is facing capital murder charges. People really don't normally get out of jail before trial on capital murder charges, but I do think that Melly's attorneys make some fair points right there. It's something that's been brought up in the past, his treatment, how long this case has been taking, the conduct of not only BSO, but also of the prosecutors. You know, this is an interesting trial, but that's what we got. If this judge ends up agreeing that Melly has had his constitutional rights violated, he may very well be released. Now, like I said, there is a small chance of that, probably like 10%, 15% chance of that happening. But it could happen. We'll just have to wait and see. But that's basically it for the video, guys. If you enjoyed the content, be sure to hit the like button, subscribe, tap the notification bell so you get notified every time I upload a video. As always, it's been fun rocking with y'all, man. I'm out.